In the matter of Bakweni Bamare versus Grantham, Mary and the Director General of the Department of Rural and Land Reform, Minister for Rural Development and Land Reform, the following judgment is handed down. Just for purposes of this judgment, we'll go through just the broad basis and the history of the matter. The applicant is Bakweni Bamare, a community that successfully applied in terms of the Restitution of Land Rights Act 22 of 1994 for restitution of land around Buccleuch and Midrand, South Africa. A significant portion of this land is a piece of privately owned land, the Downtown Farm, a 97-hectare farm bordering Buccleuch and across the highway from Waterfall Estate in the Mall of Africa. Pursuant to this award, the owner of the land prior to the restitution award, Ms. Mary Grantham, and the Department of Rural and Land Reform, represented by the second and third respondents, entered into negotiations and a dispute arose on the value of the land. The deadlock prejudices the applicant, who places the discord before the SABWiL Human Rights Court. The applicant has waited many years for the restitution of the land, and the delay in ownership transfer owing to the dispute is intolerable. The first respondent is Ms. Mary Grantham, a 50-year-old widow. She is the last surviving daughter of Earl Grantham and inherited the Downtown Farm from him. The department alleges that at present the land is zoned as agricultural land and is prepared to pay 940,000 rand. Ms. Grantham alleges that this calculation fails to take into consideration the current process underway to rezone the land as commercial property and the plans to develop it accordingly. She says that the true value of the land is therefore 15,791,388 rand, but she is prepared to accept no less than 10 million rand for the land. The department insists that the proper calculation of the land must be based on its current use. Ms. Grantham avers that this is incorrect. She says that the process for rezoning and developing the property is well underway. Many of the permits have already been filed and are awaiting approval, and of concern, a special purpose vehicle has been set up for the development, and it has accumulated a significant amount of loans to fund the development, for which Grantham has signed surety herself. Grantham alleges that the total amount spent or secured over the farm amounts to 900,000. Over and above this, the farm is her only asset. She explains that after being widowed at the age of 30, she moved back with her father and began to work together with him on the farm. Gradually, she took over the entire operation thereof. Aware of this, Mr. Grantham, while catering for his other two surviving daughters, made a specific provision in his will that the farm and all its assets be inherited by her alone. Ms. Grantham argues that if the future potential land use is disregarded in the compensation calculation, she will suffer a severe injustice if the department's position were to be accepted. The net effect would be that her means of survival and her entire net worth would be eliminated. This is because she would remain liable as surety for the debts of the Downtown Development Corporation, which would draw almost all of the compensation awarded by the state. On the other hand, the community would benefit from the ward of land that is in prime position for future development, and if properly developed in less than a decade shall be worth at least 500 million rand. She alleges that she has never studied or developed a career, and instead was totally dependent on her husband until his death, and thereafter on her father and the Downtown Farm. The plan to develop the farm into commercial property was intended to provide for her retirement and to ensure that she had sufficient means to live until her death. She argues that a failure to take her personal circumstances into account results in compensation that is not just and equitable. The department argues that the land must be considered in its historical context. It was first acquired by the Grantham family in 1920, the community residing thereupon having been forcibly removed a few years earlier. Its use has, since that date, always been agricultural. To date, it has remained a successful farming operation that in recent days operated as a craft beer brewery. It is still marked as agricultural land and has been valued by the City of Johannesburg at 940,000 rand. The department further warns that if Ms. Grantham's argument is to be accepted, the land reform process would become unsustainable. It would mean that the simple earmarking of land for commercial development will result in the rapid escalation of the price of land, and thereby making compensation entirely unaffordable. It also argues that the individual circumstances of owners should not be taken into account, and that the matter should remain confined to concerns pertaining to the land, such as the factors listed in Section 25(3) of the Constitution. What is before us is what amount is just and equitable compensation, taking into account the spirit, purport, and objects of the Constitution and Section 25(3) thereof. The factors to be considered by courts when reaching just and equitable compensation are set out in Section 25(3) of the Constitution. The section reads as follows: The amount of the compensation and the time and manner of the payment must be just and equitable, reflecting an equitable balance between the public interest and the interest of those affected, having regard to all the relevant factors, including the use of the property, the history of the acquisition, the market value of the acquisition, the extent of direct state investment and subsidy in the acquisition and beneficial capital improvement, and the purpose of expropriation. Now, we've looked at the factors that has been listed in Section 25(3), and we find with regards to the use of the property, that the use of the property was an agricultural property, still is an agricultural property, and that the fact that it is currently in the process of being rezoned should not be taken into consideration for the development, for the determination of the price of the property. That unfortunately is not in favor of the first respondent. With regards to the history of the acquisition, it is not clear from the papers it is clear from the papers that the property was acquired in 1920, and that a few years prior, the residents on the property were forcibly removed. It is not clear who removed them, and it is also not clear whether it was 100 years as alleged by the first respondent. That is in paragraph 10 of the statement of case. Sorry, I just want to move my notes so that it's not all over the place. So, based on the history of the acquisition, and that there's no knowledge as to whether the property was actually in fact purchased, whether a purchase price was paid, we would have to say that from what we have seen and the facts, that no purchase price was purchased for the property, and that they acquired it through common law, and it's not clear that that was done through 100 years of occupation from the papers. Then on the market value of the acquisition, we can't, even though the point guard principle is relevant in this instance, and for this case only, we say that it is slightly distinguishable. The principle we still believe is sound and should be followed if the facts support that principle. And the reason why we say that, it's because it's not clear when notice was given and when the rezoning happened. And because that there is a disconnect on the papers as to when that had taken place and when rezoning had actually happened, we cannot say that here's the line drawn in the sand. The notice was given on X day, what happened prior, what happened after. So in this respect only, we're going against what the point guard principle has said, because the facts doesn't support the application of that principle, although the principle may be sound. There is no direct state investment and subsidy, that was conceded already. And the purpose of the expropriation, we all know, was to benefit the community that was forcibly removed many, many years back. However, we would consider the personal factors of Ms. Grantham in looking at what is just and equitable. Because in this case, we think paying out the 940,000, even though it's agricultural land, won't be just and equitable, based on the fact that we don't know when the notice was served and when the rezoning occurred. If the notice was served after the rezoning, then Ms. Grantham is entitled to more compensation than just the 940,000. However, if it was the other way around, Ms. Grantham wouldn't. There is also not clear on the facts when this had happened. Therefore, on what was shown on the facts about the expenditure Ms. Grantham had occurred of 900,000 rand, and based on the valuation of 940,000 rand, and we've looked at the factors that would benefit, so that if you look at that quotation that was quoted by, it's in the first respondent's head, but quoted by the second respondent. The word compensation has a strong connotation of equality between what is given and what was lost. So if in fact Mrs. Grantham had occurred sureties of 900,000, she would lose that, plus the land, which is what would be lost, and would not be compensated appropriately for it. Therefore, our order is that the application for a just and equitable order could be an amount to be paid to Ms. Grantham of, we rounded up 1.9 million. I just wanted to check if we did round it up, of 1.9 million, which is the 900,000 plus the 940,000, just rounded up to 1.9 million compensation, which we find would be just and equitable for the expropriation. That is our order. Okay, so that's the law done and dusted. I want to give feedback though on your presentation and on your written heads of arguments and your submissions. Let's just find my other set of papers. Okay. What normally happens in courts nowadays is if you're relying on foreign courts or unreported judgments, you hand up the case law. So some of you refer to foreign judgments. Do not always assume that the judges will have access to that judgment or it's easily available for them. If it's not easily available, they're not going to even bother looking at it. So if you think that the judgment is worth having, have copies made so that you can hand it to the judge, so that you know they've got it now before them and they can look at it. Your heads were done very well. I mean, it was a difficult case for you as well as for you, for both parties, I think. You had a difficult case. I thought your heads were well written, well presented, and well thought through. Small little things like spell check, please, you have to do that. 1 spelling mistake or 2 we can look over. When you come to 5, then you're thinking, maybe you didn't proofread it properly, because it just becomes more irritating and it detracts from the substance of your case. So check the spelling. I'm a very freakish with regards to formatting, but I said to my deputy here that I won't even look at formatting. I will just, for the sake of this thing, think it's formatted properly, and then I won't even go there. But also look at your style of formatting. I know from your first draft to your second to your final heads, the formatting was vastly improved, which I thought was a good thing. So have a look at the issues of formatting. With regards to submissions, I thought you all spoke very well. You were a bit fast, Mr. Lutendo. You ran away a bit. You should always watch whether the judges are making notes so that we can capture all your arguments. I think you, ma'am, I forget the name now. I feel so bad. That you were very reliant on your notes. So when you addressed us, you were looking down more than you were addressing us. However, when you were asked questions, you were able to address us and answer us quite well. So, and I'm sure it's with experience, but in time you should make your notes and know your matter so well that you just need to have a word to say, oh yeah, I must say this, and then rattle off what you need to do, than as to looking at your notes while you are addressing us in your submissions. I think the junior counsel were brilliant. I think you addressed our issues. You looked at what we had said and try to answer our questions. So I think both junior counsel, you should get an applaud, because you were just very good. Both of us thought you were very good. And more importantly, the facts. Know your facts backwards. Backwards and forwards and backwards again. Your little thing about factual inaccuracies that you started telling me about, things that you didn't know about, and you believing things, and we're here on facts. Okay? Don't make facts up. If you don't know the facts, rather say you don't know the facts. Or your instructions are that this is not the case. If you don't know it yourself and you were informed by somebody, that you can't say whether that is correct or not. Rather know your facts backwards and forwards, because you will lose your argument purely because you messed up on facts, and you don't want to mess up on facts. Rather lose because you knew your facts and the judge was just being funny and didn't want to side with you. Rather use that as a basis than having the facts thrown in your face that you didn't know your facts 100%. And that goes for both parties. And concede when you need to concede. When you know there's a concession you have to make it correctly so. Because otherwise you just become argumentative, and then it also, not that you guys were argumentative, you conceded when you needed to do on one of the questions posed by the Deputy Chief Justice. So that's a good thing, is to concede and know when to concede. But otherwise we thought you'd done very well. You were very good, well composed, your arguments were well thought through. You had a terrible case to jump hurdles left, right and centre. And even if somebody has a bad case, you still have to make sure your case is rock solid, because you punch one hole into one of your arguments, and then you thought that a case was on your side. But nowadays judges decide they don't need to be bound by precedent any longer. They can go their own route, and then you end up thinking, but we had case law against us, for us, and then you find out that you've been blown. So no matter if it's an easy case or a difficult case, you have to prepare as equally well, so that you can kill all the arguments on the opposite side. Remember, oral argument is addressing their points. So you must persuade me that their points are incorrect. Don't persuade me your points are correct. Persuade me their points are incorrect, and vice versa. Okay, but I thought it was very well done. So thank you very much.
Just one more point of useful tip as well, is that all of you did very, very well in terms of your oral presentation.
Yes.
However, just one tip, and that is that sometimes written heads or written notes can actually become a hindrance. And it happens with very experienced counsel, is how to use your heads. Do you just read from your heads? Do you glance at your heads? When do you glance at your heads? And this comes with practice, and it comes with confidence as well. Just remember that as much as you're standing up there thinking, when do I refer to my heads, or how do I refer to my heads, the judge is even more in the dark. So if you're going to transition between an opening statement or an off-the-cuff address into reading something, just remember to take your judge by the hand and to say, I'm now going to refer the court to page something, paragraph something, the following case, just so that it just helps the court to know where you are in your argument. But we thought you guys did very, very well.
I don't know if we're supposed to tell them the marks.
It's up to the justices, but justices gave a great indication, so it's a discretion.
It was very narrow. It's 2 points, literally 2 points between the two of you. We all rated you very well on your presentation. Most of you, did exceptionally well. Majority got 4s, and your oral argument, you were all tie on your presentation of oral argument. We were both tie on it. So it was literally just 1 or 2 things that separated the two of you, other than the law, but on presentation and style. Thank you.
Thank you very much, Chief Justice and Deputy Chief Justice. On behalf of SABWiL, we would like to express our appreciation for you, Anthea, and for you, Sam. To have taken time out from your busy schedules and fully immerse yourself in upskilling university students and hopefully cultivating a passion in them to make them want to strive to higher levels. And students, we are very fortunate to have Anthea and Sam here. They are amongst the best in the profession, and the feedback that they've imparted today is very relevant because it's issues that us as junior council grapple with every single day, and it's a process of refining and refining and refining, and it's difficult to know what to refine unless you have sessions like this where our seniors can tell us, work on these points, focus on this is what you're good at, get better at it, this is what you need to work at, and it's this constant upliftment. And we're thankful for you, and students, we're thankful for you to have come out and joined us and participated so fully today. Thank you.
Thank you so much. Thank you.
Thank you.